Good Monday morning to everyone. I declare the meeting open. Welcome to meeting number 118, House of Commons Standing Committee on Industry Technology. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Pursuant to the order of reference of Monday, April the 24th, the committee is resuming consideration of Bill C-27, an act to enact the Consumer Protection Privacy Act, Personal Information and Data Protection Tribunal Act, and Artificial Intelligence and Data Art. We're going to resume clause by clause, and I want to thank you that things are going a little bit smoother. We have Mark Shan from Department of Industry, Senior ADM, Samir Jadra, General Director, Marketplace Framework Policy, Runa Angus, Senior Director, Strategy and Innovation Policy Sector. And as you'll remember, colleagues, we were at NDP 2, Clause 2, and Mr. Williams, you had the floor.
NDP 2, so I'll give it back to you as we resume clause by clause on C27. Mr. Williams.
Thank you, Mr. Chair, and thank you. Nice to see the witnesses again. I'm sure we'll see you a few more times for summertime. Where I left off when we were debating this last week, coming back to this meeting, was talking about the definition of anonymize, and the NDP 2 amendment was to take out the words in accordance with generally accepted best practices in that definition. And we are in agreement with that. And the main reason for that is we need these definitions to be clear and concise. As it stands right now, organizations can anonymize personal information using commonly accepted best practices. However, the draft lacks clarity on these practices and constitutes generally accepted standards. The ambiguity allows for the potential reliance on anonymization techniques recommended by specific experts, which may not be adequate for a particular data set. And what we wanted to talk to for a couple of these points too, and this is very clear, we don't believe in that. It has to be very clear when we look at how this act is going to be enforced. It is by the Privacy Commissioner. The Privacy Commissioner himself has made comments to state that he needs this definition to be clear and concise, and with lack of consistency and without clear guidelines on generally accepted best practices, there's a risk of inconsistency in anonymization methods across different organizations, leading to various levels of data protection and potential undermining privacy standards. And we had a few of those examples of where that's happened and why we're looking at this. And I think the bigger point too was looking across the board when we've had witnesses at the difference between anonymization and de-identification. And the problem we've had, and the problem I had when we talked to witnesses and de-identification, was in the definition it says a risk of identification of the individual still remains. And that's a major issue when we're talking about what we're trying to achieve here. And in privacy, it should be that individuals have the right that their private information is not just de-identified, not that there's a risk of that information being re-identified, that their information is completely anonymized or their information can be protected under this Privacy Act. I wanted to give two examples of where this happened in the past. And all of us recognize that we have had our information breached, our privacy breached on many different occasions. I get emails on certain apps, or even sometimes your banking or Netflix, where there's an email that says your information has been compromised. Please change your passwords. This happens all the time. Two examples. I'm going to give one American, one Canadian, where this has happened and caused harm to consumers. In 2006, Netflix launched a competition known as the Netflix Prize, offering $1 million prize to improve its recommendation algorithm by 10%. And Netflix released a data set containing movie ratings by anonymous users. However, researchers later demonstrated that it was possible to re-identify individuals in the data set using external information. In 2007, two individuals showed that by combining the Netflix data set with publicly available IMDb data, they could identify specific individuals and their movie preferences. This raised serious private concerns as it highlighted the risk of re-identification even when data is anonymized. In Canada, we had the breach of Ontario Ministry of Health and Long-Term Care's data breach in 2011, In this incident, the personal health information of thousands of Ontario residents was compromised due to inadequate de-identification measures. The ministry had released health data to researchers for an analysis, but failed to sufficiently anonymize the data, allowing individuals to be re-identified. As a result, sensitive information such as medical conditions, treatments, and hospital visits became accessible to unauthorized parties, and this breach raised serious privacy concerns and highlighted the importance of robust de-identification practices, especially when dealing with sensitive health data. The main point is we have to be clear and concise. We have to ensure that the Privacy Commissioner, who's raised concerns about this definition, does not see ambiguity when they're looking at this, but at the same time ensures that we have businesses who can't skirt the rules and be lenient with private data. And I think that's the main point we're making. Mr. Shan, I think I asked you some questions already last time we were here. I don't have the blues, so I will see if I asked this for you, but I think I asked you what general accepted best practices for anonymizing information was. If I haven't, can you please answer that?
Merci, Monsieur le Président, pour la question.
Thank you, Chair, for the question.
Of generally accepted best practices is actually that it continues to evolve with the state of the technology. It's one of the reasons why we believe it's actually an important consideration for inclusion within the Act, so that it continues to ensure that it meets the state of the art. We actually have concerns that absent a commitment to generally accepted best practices, that organizations would actually not have a North Star or a guide as to what they should actually be doing as it relates to the anonymization of information, and that there actually could be a plethora of approaches taken. And so generally accepted best practices would vary, but I think you'd find within industry and within users a lot that they could turn to as it relates to that. And I can, so that would be my primary response.
So, you know, I guess at the end of the day, you're then putting a definition in that is not defined in the Act, correct?
We're putting in a concept into the Act, which then tags along with the definition. So the definition remains anonymized as it appears, and then has the concept of generally accepted best practices, including alongside it.
So I guess the biggest question then, who is who? So who would be determining if the data was anonymized according to those generally accepted best practices? The department, the Privacy Commissioner, or is it a case of self-regulation?
So, Mr. Chair, I'd offer a couple of things. So, two things. One, all of this is definitional, which means that it then relates to the powers and obligations that people would be scrutinized by as it relates to the enforcement of the Act. The enforcement of the Act is by the Office of the Privacy Commissioner. So the determination as to whether or not someone had actually anonymized information for the purposes of meeting the test of generally acceptable best practices would be one that would be determined by the Privacy Commissioner should there be concerns about a violation of the CPPA. The conception of generally acceptable best practices, as I noted, appears within Quebec's law. It's also the approach that's consistent with what experts have called for. So the Canadian Anonymization Network, or CANON, is a not-for-profit organization with representatives from public, private, and health sectors in Canada, includes the participation of experts in the field of de-identification and anonymization, including Statistics Canada. And they stated that the inclusion of the phrase generally accepted best practices will help future-proof the definition of anonymize, as it sets a statutory obligation for organizations to consider the evolving de-identification techniques and standards that would sufficiently protect personal information for their industry and context.
And we've heard from some of those witnesses, but it was the Privacy Commissioner himself who noted that this was not something that he'd like to see in there, especially if there was not a clear and concise concept of who was setting those and what businesses knew the best practices were. Do we have other countries that we've looked at? I know you've mentioned Quebec, but did you look at other countries that had generally accepted best practices in their legislation when it came to anonymization?
The one I'm most familiar with, Mr. Chair, is Quebec's Law 25, which does make that I'm not sure of others.
Okay. And from what we've seen, there aren't many others, and the GPPA does not have that in there. When it came to consultation for this, we of course had many witnesses here at the committee. And you met yourself personally with quite a few witnesses, is that correct, in the department?
That's correct.
Did you meet with all the witnesses that we had here at the committee?
I'd have to review the witness list, but I'd say over the course of the years I've been within the department, it's probably likely that I've met with all of the witnesses that you had testimony from.
Did you meet with any witnesses more than others? Were there any that requested more meetings with you on this and other topics of this?
I'd have to review. I'd say in general, there's a strong representation from the academic sector and a strong representation from industry.
Of that, we did know that you met with the Canadian Marketing Association, who've been strong advocates for this kind of language being included in the bill 10 times. Are you aware that they're trying to keep, so reasonable or to keep general best practices in this definition?
I know that that's one of the issues that the CMA has raised in their submission to this committee.
Okay, and I know we've had some testimony, but just because you met with them 10 times, are they stating that this is going to hurt their business if they don't have this included, or were there any concerns that this definition of anonymization could be too strict for them?
No, I think you'll find the specifics within their submission and as well as within their own testimony. But I think their view is that I don't want to paraphrase their view, but I understand it that they would like a standard by which they could actually know where to follow, and they want to be able to ensure that there are standardized approaches, which is why they believe generally acceptable best practices, I think, is helpful.
In terms of how that's going to be identified, so generally, accepted best practices, is the department going to have those best practices? Is that something where if it was included, there would be a list somewhere that public and businesses could find that?
So I think there's two considerations for that. One is there is industry standards that can be referenced and leveraged, and there's a specific opportunity for that within the CPPA, and then there's the opportunity as well for the Office of the Privacy Commissioner to issue guidance.
Sure, but to my point, I guess if the Privacy Commissioner is stating in the onset here that this provides no guidance, that it's going to be ambiguous, I'm just wondering where it's supposed to live, and I go back and our fail-safe is to go to the Privacy Commissioner, because at the first and foremost, the whole premise of this act, where we're coming from on this side, is that privacy needs to be a fundamental right, and there should be no ambiguity. And if it comes to the fact that some organizations want this wording in to provide more elbow room, that's not really what we're here for. We're here to protect privacy's fundamental, or Canadians' fundamental private rights. And when we look at this bill, I can't see any reason why, so far, except for it being in Quebec's legislation, that we're seeing it as a best practice anywhere else to include this language, except for the fact that some of these organizations, like the Canadian Marketing Association, are saying that it's not going to allow them to collect and be free with more Canadians' private information. So, Mr. Chair, I'll leave this here just so the rest of the committee can come in. But to our side, we can't see why this amendment would be here. Thank you.
Monsieur Williams, Monsieur Garon, la parole est à vous. Ensuite,
Mr. Garon, you have the floor, then Mr. Massé, Turnbull, Généreux, and Burke. Thank you, Chair. To follow up what Deputy Williams just said, they introduced a notion of best practices, which has evolved quite rapidly. We've seen it at the University of Toronto, who appeared before the committee. It was effective a few years ago, but currently doesn't appear to be. So they'd like to introduce into the law the concept, not the definition. And of course, if there's any problem and if it's put before the courts because of the uncertainty. Why was a concept of best practices adequate? And we were told, well, there's no definition, it's a matter of interpretation. If you end up before the courts, it's problematic. This doesn't seem to provide any uncertainty. There seems to be a certain consensus on how businesses will interpret that. Well, the concept of best practices has to have an objective, and the objective is to make it almost impossible to re-identify, re-establish the identity if it's been anonymized. So the best practices available in order to attain the objective, maintain that anonymity status. So it's a method. There's no real objective. It's a method to compare a process. Well, I'm talking about the best interest of the child, of course. There was an objective. That is an objective, particularly with children. So why? In some cases, anonymity and ambiguity is okay, but in other cases not. To your knowledge, is there one technique, an only technique that would allow 100% guarantee that individuals would not be able to be identified? Or is there still a risk? Well, it depends on case by case. There's a lot of different applications of this data, of individual private information, and a lot of different contexts. A technical environment, of course, allows some slippage, if you will. So I'm not an expert in the field, so yes, there has been technological evolution of these methods. What I'm trying to have you state clearly, if there's a clear objective of to not identify or re-identify, in a previous life, I know that there is really no single technique that's 100% watertight. There's a lot of ways you can re-establish the identity of individuals. So what is the adequate, acceptable level of risk? And who determines the basket of technologies? Because there is a basket of technologies, there's not a single one. And it has to match and be compliant with a certain acceptable level of risk. Well, who determines? Other than, depending on good faith. Well, there is a definition of anonymization, and in the implementation process of this act, the Privacy Commissioner determines if an organization has, in fact, respected and applied these definitions. So the Privacy Commissioner will keep a list of best practices. Well, if there is a suggestion that privacy has been breached, the Privacy Commissioner will examine whether or not the rules were applied or the regulations. And of course, it all depends on the particular context. We don't say the generally acceptable practices. They say that which is essential to anonymize, de-identify, if you will. And you have to consider the available technology. Well, essentially, somebody has its rights breached. The commissioner takes a look at that, studies the case, see if the enterprise actually followed best practices, and provides his advice on the issue. Don't you feel that if there was a regulation which would allow the commissioner in advance to determine a certain number of best practices, instead of having the individual having to bring forth a complaint to the privacy commissioner? Your digital identity would be lost in that case. Well, the law should favorize those practices, the guidelines, which would allow corporate entities to consult a legitimate source of information. There's two aspects to the use of this. First is standardization or harmonization of a certain practice by business. Economy of no, I know I'm interrupting you, and I apologize for that, but this is a necessary conversation here. How do we standardize those processes when the process of de-identification or anonymization is part of it's a commercial advantage to anonymize? So how can we ensure standardization if we don't have a definition? Well, that's true of a number of standards. There's an objective, and the method or the processes, like ISO, will create a standard to confirm, give their stamp of approval on best practices. And because of the rapid evolution of the technology, well, that's basically the reason why the Canadian network, Canadian anonymization network, and a lot of civil society organizations want to ensure that. We'll be able to increase the number of processes. In fact, it's a basket. Well, I have to ask a question to Mr. Massey. I don't have any problem with the amendment per se, but I don't see what we're attempting to accomplish with it. I'd like to better understand the objective that's being followed, parliamentary speaking. Monsieur Garon is going to be the next speaker on my list, so.
Question, and first of all, I think there's a couple things to clarify with the original discussion that was made of this. It was interesting that some were attempting to use the privacy commissioner as a reason to get rid of this amendment, when this actually amendment comes from the privacy commissioner himself. And it comes and starts on page 14 and 15, and I can provide some clarity on both points that we're making here. First of all, in his submission to ourselves, colleagues, it is under the definition of de-identification and anonymization, recommendation 7, strengthen the framework for de-identified and anonymized information. And what the Privacy Commissioner said is that the OPC supports the introduction of a new framework for de-identification and anonymization of Bill 1727. The framework has some positive elements. For example, it provides flexibility to organizations using de-identification information and adds some needed clarity as how and in what circumstances de-identified personal information can be used and disclosed. So right there, that's opening the door for businesses and their ability to use some measures. He continues with, that said, as currently drafted, it provides too little protection for de-identified and anonymized data. And this is where we get to some specifics about, I guess, philosophy of this. Best practices. Can you name who is going to actually make the best practices, Mr. Shan?
As I noted, Mr. Chair, there's a number of mechanisms by which
Not mechanisms, who and what companies will make best practices?
Mr. Chair, if I can complete my sentence, I would say that industrial standards organizations, which have a necessity to be tripartite in their formation, including the participation of academics, civil society, as well as industry, are often party to the making of industrial standards. Which
those are actually part of them, and that's a basic point we have here, is that you're either siding with the decision of people having de-identification and anonymized information being protected from themselves, or having an industry led by Google and others and their associations, some of which actually have other funding and so forth. And what's interesting is this issue with regards to the Quebec consistency, and I think it's an important one, a distinction the Privacy Commissioner has addressed, and also it's also been addressed by testimony from Diane Poitras, the former president of Quebec's Commission of Information, and on specific, the Quebec legislation with the relevant provision in Section 23 is this: where the purposes for which information was collected or used are achieved, the person carrying on an enterprise must destroy the information or anonymize it to use it for serious and legitimate purposes, subject to any preservation period provided by an act. For the purposes of this act, information concerning a natural person is anonymized if it is, at all times, reasonably foreseeable in the circumstance that it's irreversibly no longer allows a person to be de-identified directly or indirectly. Information anonymized under this act can be anonymized according to generally accepted best practices and according to the criteria and terms determined by regulation. And part of that, in the testimony that we received also from the Privacy Commissioner, was because they wanted to fall on the side of caution at that moment. But what's interesting from Mrs. Poitras, the former president of Quebec's Commission, as I mentioned, who stated in response to a question that, quote, "If I understood correctly, part of your question was whether we have any concerns about the interoperability. There are a couple of things I have concerns about. Among other things, there are important distinctions in the regimes applicable to anonymized data and de-identified information." So the door was left open to be actually improve the situation even for the residents of Quebec with regards to having empowerment over some of their data, and that there's quite a comfort level that having this difference is okay. And so what we are really talking about at the end of the day here is whether or not best practices, which will be industry-led, policed, and determined, used against the OPC, because best practices, if there is a distinction difference, will be used against the OPC, the Office of the Privacy Commissioner, with regards to that. So basically, at the end of the day, this boils down to having faith in whether the Privacy Commissioner should have control over this measure or whether or not we want it to be industry-led. I'm going to side with the Privacy Commissioner. Thank you, Mr. Chair.
Merci, Monsieur Massé. Monsieur Turnbull, la parole est à vous. Ensuite, j'ai Monsieur Généreux et Monsieur Perkins.
Thanks very much, Chair. Great debate on an important consideration for this bill. Just maybe to go back to anonymization is, in our view, privacy enhancing by nature, is it not? Mr. Shan, can you just speak to that?
Enhancing mechanism because it does render the information unre-identifiable.
And so we see sort of teased out here in various different comments that the Privacy Commissioner in this case is saying essentially if you add generally accepted best practices into the legislation or the definition of anonymization, that this could open the door. I think our position is that it's the opposite, that in fact, putting this in there allows for the evolution and the emergent properties of best practices to help inform. Could you provide a better rationale? Because I feel like this is the main difference that, Mr. Massey is pointing to the OPC, I think, and wanting to suggest that he's siding with the OPC. We're not against the OPC. I think it's what is the best mechanism to, encourage anonymization and to do so in a way that recognizes that the technology is advancing and evolving.
Yeah, thank you, Mr. Chair, for the question. I think absent the terms generally accepted best practices, the definition has nothing but a goal, which is an incapacity for re-identification. I think our view is that the term generally accepted best practices obligates organizations to continuously ensure that anonymization techniques they use are in line with evolving standards. Without the reference to generally accepted best practices in the definition, organizations may determine for themselves what is an appropriate technique, regardless of whether it meets widely recognized standards or even a credible technique. And so I think our view is actually by obligating in the definition organizations to conform to what is the best-in-class approach to anonymization, that we've actually got a higher standard than just leaving it as solely the goal.
Thank you. And if Quebec's law obligates companies to abide by generally accepted best practices, if the law that we end up passing through this committee doesn't include that, what would be the risk there? Because it seems like that would compromise interoperability. Wouldn't it also have some kind of an impact on, potentially at least, I could foresee that, best practices in Quebec would be recognized, but perhaps not in other provinces across the country? Wouldn't that create some problems?
So obviously, I think what we're hoping for with the construct of generally acceptable best practices is that we set a very high standard that requires corporations to continue to evolve the process and ensure that they're using those best possible techniques. If there's an obligation in Quebec to do so, but not in other places, there runs the risk that some organizations may not be seeking out those best techniques, and that will have differential privacy depending on which law you're conforming to.
So, and then the other thing I wanted to ask is, who are the experts on anonymization? Because we've heard lots of people reference the Privacy Commissioner, but I imagine that the Canadian Anonymization Network, who's been asking for this to be included, might actually have more experience when it comes to anonymization than the Privacy Commissioner. Nothing against the Privacy Commissioner. I love the guy. He's fantastic. Dealt with him when he was the legal counsel, and he was just fantastic. So utmost respect for him. But isn't it true that the Canadian Anonymization Network, or CANON for short, has a lot of experience? And what are they saying about this?
So CANON is a not-for-profit organization that does have representation from public, private, and health sectors in Canada, and also includes the participation of experts in the field of de-identification and anonymization, including Statistics Canada, for whom the anonymization of information is a principal consideration. And so I do think there is a well of capacity and expertise in their recommendation that generally acceptable best practices is a useful standard to hold people to.
Thank you. And then to the point that this is one of the strengths of including this is that it evolves. I think some of the comments we've heard from others suggest that if it's not an exhaustive list today, that in essence that provides some ambiguity, that will be taken advantage of. But I think that the opposite is the case. The argument can be made that, well, it needs to evolve because the pace at which the technology and the methods for anonymization are changing quite quickly. So, but I guess, how do you ensure that the OPC can, what's the mechanism for continually updating that? Because I think that's kind of the clarity that a lot of us sound like we need to have in order to feel like this is robust enough that it's not going to open that door. So how do we contemplate or envision the sort of general guidance around generally accepted best practices evolving? Would it be the OPC guidance? And where would the expertise come from?
I'll defer to Mr. Chhabra on this one.
Thank you very much for the question. I think it's important to recognize that de-identification and anonymization techniques live on a spectrum. Anonymization is at the far extreme end. De-identification is something far more simple. The committee, in its earlier deliberations today, referenced some cases that go back to kind of the mid-2000s where information was stripped out of a data set and it was easy to re-identify it. And that's exactly the kind of issue that we're trying to combat by establishing a higher bar for anonymization. Anonymization techniques are generally algorithmic in nature. They involve things like differential privacy or k-anonymization. These are very sophisticated mathematical algorithmic techniques that, of course, because they're algorithmic in nature, can over time have their efficacy degraded as other algorithms are developed, as new mathematical techniques are developed, as computing becomes more powerful, vis-a-vis quantum computing, for example. There are opportunities downstream for what was one point considered anonymous in nature to later, in a matter of years, become much more easy to break. And so the reason for including a standard that says generally accepted best practices is because it requires an organization to continually review and update The whole point of anonymization in the context of the Act here is to ensure that anonymized, truly anonymized data can be used for beneficial things like improving health informatics, improving health system and delivery. When it is at risk of re-identification, it means it's then back into the auspices of the Act and all the requirements apply. In practice, the way we would see the Office of the Privacy Commissioner using a generally accepted best practices requirement is if there were a case in which there were a security breach or that personal information was leaked, they would then be able to go and point at the Act and say, the Act requires that you anonymized in accordance with generally accepted best practices. And we can or cannot find evidence that you have done so or that you've maintained a modernity or contemporaneously with generally accepted best practices. So maybe you did it 8 years ago or 10 years ago, but then you left the data set alone and it became breachable. What this does is it requires a constant evolution of standards that say, if you're going to try to maintain this as being an anonymized data set and the protections that that includes, you have to keep updating the standards by which you've applied that anonymization.
So in essence, because anonymization includes not being able to re-identify, and the anonymization process and techniques are evolving quite quickly, that if you don't have this, then what's the risk? The risk to me is that perhaps it goes out of date, or organizations, companies are not keeping up with the pace of those generally accepted best practices. So what's the big risk, though, in terms of the public and privacy concerns? Because Ms. Samir or Mr. Chabra, your comments really sort of point to a risk that I haven't heard anyone talk about yet, which I think is part of the main point why our position is against removing this clause.
We've acknowledged the construct of anonymized information, but have set the bar for essentially its usage very, very high. No reasonable prospect of re-identification, and second of all, a conformity to the generally best practices. And I think absent that, the worry is the commitment is solely to the purposes of non-re-identification, and it doesn't necessarily provide that ongoing obligation back to industry to say, actually, have you assured yourselves that you're continuing to meet the new bar?
So that bar is continuously moving. So the standard that we're setting is something that will continue to increase as technology evolves. And that obligation for those companies would then be tethered to that moving target, which is that the standard best practices are going to have to be followed, and they can't just check out and use outdated anonymization techniques and forget about staying up to date with the best practices. Am I right?
That's correct, and essentially ensures that, as opposed to having a potential for a re-identification test that then that then ultimately results in a breach and then is revealed by the Privacy Commissioner to not have met the standard. Instead, there's two elements. There's a non-re-identification and a commitment to the use of generally acceptable best practices, which means that you're continuing to ensure that you're actually drawing on the techniques that are most modern.
And maybe just a final point, just to really punch home the point that this, leaving this in other words, not taking it out, which the NDP have proposed, continues to align Canada's legislation with Quebec's privacy law. And also, I would just want to point to the fact that our next amendment, which is in consideration, which Mr. Massey read out, the Quebec law is on reasonably foreseeable risk. We're also including to further align our legislation with Quebec's privacy law. Is that correct?
That's correct.
Okay, thanks, Chair.
Merci beaucoup. J'ai Monsieur Généreux.
Thank you, Mr. Généreux. To the witnesses, the series of questions I'd like to ask you is not on the amendment per se, but on the process which has led to this motion or amendment. The definition is very important for the bill. You'd agree with that, I'm sure. and on the interpretation of the bill if and when sanctioned. Now, my question is not any accusation here, but I just want to understand the process. The government tabled this a couple of years ago. We began hearing witnesses, and we have over 50 government-sponsored amendments. Are you the drafter of this bill? No, not personally. I work in concert with my colleagues at the Justice Department to ensure that, but policies established by the minister last September, the government brought forth a number of amendments, which were the result of some consultations, because this was done after the tabling of the bill. You have consulted with approximately 300 parties, but during the consultation, some people were called. They weren't in the original 300, and they complained that they weren't consulted, or they would have liked to have been consulted. We've been told on many occasions that there should have been more consultation on this bill. So today, we're dealing with a series of amendments, this one and another, which demonstrate once again that some people wanted to challenge or test your drafting of the bill. I suppose the reaction was more intense in certain cases than others. The anonymization network, for example, we met with them a number of times. What was the need? Why did you have to consult them over a dozen times on that? With the analysis that we've had here at the committee. Thank you very much, Chair. Look, we're fully open to hearing from anybody who wants to discuss this bill. And my response has been the same. Perhaps not myself personally, because, but I mean, I'm busy. I'm here before the committee fairly often. There's two important aspects to your question, I believe. You've also consulted with Canadian Marketing Association and Canon. That's a separate, it's a non-profit organization and network as well, constituted with a number of experts. It's also a not-for-profit. It can also with the university sector, academia. They've had numerous meetings. On the bill, because of their interest in it, of course. And my response has always been, I'm prepared to hear them out. Well, the amendments that you're now proposing, because you withdrew one that was proposed by the minister in September, now we have about 50-ish proposed amendments made by the government. Now, did this occur after you met with those other groups, or particularly those witnesses that did appear before the committee, or further meetings that you've had with other groups, which you might have met with about a dozen times? Well, it's not a linear relationship. I mean, one meeting and then brings forth one amendment. We have people come forward with a specific interest, and it's up to the department to analyze that and see that the bill continues to meet or attain the objectives that are determined by the cabinet and the minister. Okay, I'll come back to the actual amendment that we're looking at. The government is proposing a new definition via the NDP is proposing another definition, a different approach based on the Quebec bill. What's the government's intention in modifying or not modifying the definition, which we believe is a little less appropriate than the definition proposed by the NDP because it is consistent with the Quebec bill. So for those that perhaps lobbied you to try to influence you a dozen or so times, are you still meeting with them, even today, presently? Well, double-barrel question there. It's important to clarify it there. One NDP amendment, which deletes a few words in the definition which are in the proposed bill, which was initially proposed. And the definition that we had initially is in fact in keeping with the Quebec legislation. And the reason for this is to encourage the use of anonymized data because it improves or increases the privacy of our Canadian citizens. And it's in keeping and respects the spirit as well as the letter of the Privacy Act. Well, the law is in effect. The Privacy Protection Act is in effect, but many stakeholders brought forth some analyses are at the base of this recommendation, which was proposed in May 2022. Do you believe that the number of representations made by certain groups, some much more frequent than others, might leave the impression that the industry is trying to lighten the bill or make it easier for them to facilitate their work, trying to protect fundamentally privacy rights? The goal of the bill is to protect Canadians and their privacy. Did you have the feeling that these organizations wanted to, well, can I use the expression, water down the bill so it'd be easier for them to interpret it? Well, I can't really give an opinion on the intent of these groups, but in my conversation with them, various sectors, there's usually two objectives: to have something that is of a high enough standard to make it clear and that can be implemented. And the second objective is, in fact, to protect the private data of citizens, to remove the ambiguity. That's it. Thank you, Mr. Généreux. Mr. Perkins, followed by, well, we'll start with you, and then we'll carry on.
Thank you, Mr. Chair. Thank you, witnesses. Take a step back, Mr. Shen. What's the purpose of anonymization?
Explain, there's a continuum of privacy enhancing nature of kind of the state of a piece of information. On the one end is anonymization, which essentially renders it incapable of being able to re-identify the individual. And then on the other hand would be fully declarable, or I don't know what the right term is, but essentially understood who the individual is and its fullness. And I think the goal is to create a continuum of likely states of information, recognize their existence in the commercial context which the CPPA will regulate, and ensure that appropriate safeguards are placed along each stage of the continuum, and then encourage potentially the usage of information in those states with the appropriate safeguards in place at each stage.
So, what's the purpose of a company being forced to take it to that final test of making sure it's anonymized? Is it because they're sharing it outside their organization, or what is the purpose for that? Because if it's information you've gathered internally, obviously through your customer base or whatever, you don't need it anonymized unless you're sharing it in some way.
I think the use cases for anonymized information would vary, but I think there is an understanding that information potentially can be still rendered useful, potentially either within the organization or outside of it, because again, even within the case of identified information, it needs to be prescribed to the purposes for which it was collected and only utilized. And the law specifically states that people should minimize information only for its most necessary uses. And so even in the case of in one's own organization, there would be use cases potentially for which anonymized information might still be valuable, but wouldn't rise to the level of providing either de-identified or identifiable information to those parts of the organization, because there's not a use case specific to why it would leap to that level. Particularly in increasingly large and aggregated data sets, they can have value without necessarily needing identifiable information there within.
So as an example, I'll just draw it to my past life as a as a retail marketer. I would be a member of a coalition program. A coalition program are programs like Air Miles. We would collect and get access to the data of what our customers would be using Air Miles for and how it would impact the sales. But we also could get access to data. We could also get access to data from Air Miles more generally of what people are doing of certain profiles, but it wouldn't necessarily be with an individual identifier on it. It would be people in a certain income bracket or geography or whatever have these other purchasing patterns, so I could draw some conclusions. That's a case where I might be buying or getting anonymized data as a marketer. It's that kind of thing, right?
Yeah, I think the use case would determine whether or not that information was de-identified or anonymized.
Right.
And I think in many cases where people think they might be dealing with anonymized information, they're actually dealing with de-identified
All
information.
depends on what their terms of use are when they signed up for, in this case, Air Miles or something else.
Well, no,
what they agreed to.
it actually depends on the techniques that have been utilized to strip out any personal identifiers.
Right.
So a de-identified set, like a loyalty program, may still have enough discernible information to actually constitute itself to be identifiable or de-identified. Sorry, so they would not rise to the level of anonymous information. They would actually they'd actually still be considered to be de-identified.
And that's a great point, because we had testimony from organizations like Canadian Marketers Association and others here before the committee that said it's impossible to anonymize and that this definition was too strong, and from others who said like the Privacy Commissioner and others in the privacy space actually is. It's just not strong enough language. So the idea is to get it to the point where it's impossible to re-identify. But you said a few moments ago that to the point that it's almost impossible. So the purpose of the government is not to get it to impossible, but almost impossible. What do you see as the difference?
So I think you'll see in G2 the construct of reasonably foreseeable, which is to say, I can't, which is another reason why we believe that generally acceptable best practices is an important construct, is because the continued availability of other sets of information, of other techniques, of other kind of computational tools may take what was believed to be anonymized and actually shift it to a world in which it could be, which is why continuous conformity to generally acceptable best practices and a standard of reasonably foreseeable, which is I couldn't have imagined that this was possible, are the two nuances I'm introducing or suggesting are important when thinking about anonymized information.
So in the Privacy Commissioner's submission to us on this issue, I'll go on to read, MP Massey only read a small part. He goes on to say, in talking about this issue, as currently drafted, organizations could anonymize personal information using generally accepted best practices. That's the term we're discussing here. However, there is no explanation of what these practices are or what would be considered generally accepted. Including this language opens the door to the possibility that some organizations might rely on anonymization techniques promoted by certain expert groups that are insufficient for a given data set. And both the Liberal members, the government, and yourself have used Canon as an example of a organization that would provide guidance. And I've met with a number of the members of Canon, which include the big five banks, Rogers, TELUS, Loblaw, Sun Life, Microsoft, CRA Canada, Post Stats Canada, Health Canada. I look at those big corporate entities, and I know when I met with those big corporate entities, they weren't interested in a narrow cast of a tight definition because it's not in their interest to be able to be restricted in that way. And that's why if you remove this section, I think it puts more onus on organizations to focus on what the Privacy Commissioner says and interprets. And when the Privacy Commissioner, as we talked about at the last meeting around best interest of the child, the Privacy Commissioner has the responsibility under provisions of this Act to provide guidance to organizations on these areas, does it not?
The Privacy Commissioner has the capacity to issue guidance on matters related to the implementation of the Consumer Privacy Protection Act.
Right, and that's what he goes on to say in his submission, that the CPPA includes a number of mechanisms for the Office of the Privacy Commissioner to assist organizations in meeting their obligations, including providing guidance on privacy management programs, developing guidance materials, and reviewing and approving codes of practice. So the question to me is, I'm not interested that much in what are generally accepted best practices by industry associations. I'm more interested in the power of the guidance of the Privacy Commissioner, and I'm reluctant to support a provision that allows anonymization to be watered down to almost impossible, but maybe possible, because the language is given there to allow outside industry associations to set the standard and not the Privacy Commissioner. So wouldn't you agree that the Privacy Commissioner is the appropriate office to set these standards, not private sector organizations?
So I think you'll find no dispute that the Privacy Commissioner is the ultimate interpreter of the enforcement of the Act. I think as it relates to the techniques utilized for the purposes of anonymization, I think there's important voices to include, including those of academics, who are party to some of what has been encouraged in this space, as well as those of Statistics Canada, of Health Canada, of the Public Health Agency of Canada, all of whom contribute to the view that acceptable best practices can be established and upheld outside of within this remit.
But doesn't the Privacy Commissioner have the responsibility to talk to all of those groups in developing the policies and guidelines?
So the consultative obligations of the privacy commissioner are at the privacy commissioner's discretion.
Okay, so again, my preference, and I guess this is where I'll leave mine, I'll just restate that I'm not sure an organization like Canon, which is dominated by the big five banks and the big oligopolistic telephone companies and the insurance companies and large data miners globally like Microsoft, are the guide that I want to see in driving the policies around Canadian privacy law. Thank you, Mr. Chair.
Merci, Monsieur Perkins.
I should have kept talking a little.
Vous avez bien choisi votre moment. Je passerai la parole.
Mr. Viss,
As we're discussing NDP2, that if NDP2 is adopted, then G2 cannot be moved because there's a conflict of line. I've highlighted that last time. I just want to make sure it's on everybody's mind. So, Mr. Viss, floor is yours.
That's very helpful, Mr. Chair. Just building off this important discussion about widely acceptable standards, earlier today, through you, Mr. Chair, Mr. Shan did mention that the best practices line that's taken up the majority of the last hour is included in Quebec's privacy law. Is that correct, Mr. Shan? And that's why the government's adopting that language?
It's not the sole origin, but it is noted that it is one of the benefits of accepting this language.
Okay, thank you. In clause 5, under the purpose and application section of the bill, I should say on page 8, it says, for greater certainty, this act does not apply in respect of personal information that has been anonymized. So the debate I think that we're having right now is, one, we heard from witnesses like Ms. Skaza, who talked about almost the impossibility of de-identifying data based on the best practices that exist out there, that we can never be 100% sure. That's very clear. She did outline that the department seems to be very much on the side of some of those big corporations that want as much leeway as possible in the design of anonymization and de-identification to protect their corporate interests and their business interests. That's fine. That's their objective, and I acknowledge that, whether or not I agree with it. But if we're making a comparison with the Quebec law, does the Quebec law exempt anonymized data from the scope and application of the bill? So my question more specifically, is there for greater certainty in Quebec's law that would not apply in respect of personal information that has been anonymized? So is there something similar in Quebec's legislation like we have on page 8?
We're consulting, Mr. Chair. The Quebec law states that if it's anonymized by the definitions contained in the regulations, then it is out of scope of their privacy law.
So Quebec's law does the de-identified data does not apply.
Anonymized data.
Anonymized but not de-identified.
Anonymized data, as defined, as set out, is outside of the scope. Once it's been deemed anonymized, it is outside of the scope of the Quebec privacy law, similar to what would occur in the case of the CPPA.
Okay, thank you. That was my main question.
Thank you, Mr. Viss. J'aurai Monsieur Garon sur ma liste, et c'est la dernière.
Mr. Garon, it's the last name I have on my list for now, so please go ahead. Well, my question is somewhat of a follow-up on the fit between the Quebec bill and this wording. There's been some argumentation on the part of the government. We've discussed this in private as well. The fact that the Quebec bill refers to best practices. It does give reference to best practices. And the manner in which it is drafted in C27 would in fact mirror the language of the Quebec Act. But I don't think that's true, because we do refer to best practices in the Quebec law, but businesses would anonymize data as determined by the government of Quebec by regulation. So there are best practices. They exist, of course, but I don't, Mr. Massé was making the same point. What was the name of that group there? Canon? Well, it's a lobby. It's a lobby group. They represent a number of enterprises, and they come here to try to influence this legislation. We understand that. And they should be on the lobby registry. I'm not at all convinced that there won't be industry that's going to establish its own practices, and it won't be in any way compliant with the Quebec Act. Doesn't the government really want to establish some minimum criteria? I need to be convinced, but it's going to be hard to convince me. Thank you very much, Mr. Garon, Mr. Turnbull.
So I wanted to bring in, just because of the NDP2 and G2, which is another amendment that the government has proposed, which I think you all have, because the two are dependent upon one another. If NDP is voted through, then G2 is no longer able to be. So I want to bring this in because it has an impact on perhaps the debate we're having and the alignment with Quebec's law, which I think Mr. Garon is rightfully pointing out. And I think perhaps just understanding why reasonably foreseeable risk is something that is needed in order to align with Quebec's law. Mr. Chand, can you perhaps comment on that and how that concept is also both relevant but also strengthens privacy protection?
Yeah, and so from what we have consulted and analyzed in view of a number of experts, including academics and privacy researchers, and the concept of reasonably foreseeable, which is a well-established principle in law, it's mentioned almost 50 times in the existing PIPEDA, which we believe regulators and courts are adept at interpreting, is a necessary construct. Not including that term would have a potential chilling impact on the use of the technique, which ultimately leads to negative outcomes for privacy protection, because we actually think there should be increased uses of anonymization to try and render as much of the information utilized in that format rather than in identifiable or de-identifiable formats, because of the privacy protecting value of that. And in fact, using anonymized data sets could help in a number of heavy data user kind of applications, including potentially in the space of AI. And so I think that's our view of why reasonably foreseeable is an important construct.
I understand. I'm not a lawyer, but I understand that concept is very well embedded in the law, so it's quite well understood, reasonably foreseeable. Can you speak to that a little bit?
Yeah, so as I noted, reasonably foreseeable has been included in a number of statutes, but it particularly has a strong interpretive value that's been added to the existing private sector privacy law in PIPEDA, because it appears there many times and is understood as a construct that is can be tested by both regulators and courts as to whether or not it was understood by the individual at the time, whether or not they had taken appropriate mechanisms to anonymize the information.
Does it raise the bar on the obligations set out in the Act for companies to abide by adding reasonably foreseeable? It seems to me it raises the bar even further, perhaps. Would you agree?
I think what we're pointing to by both reasonably foreseeable and generally best practices is to essentially further test the assumption that someone can just say, well, I anonymized it, and to my mind, it was anonymized, to which then by saying, well, but was it reasonably foreseeable that it was anonymized? Did you actually test it against the available technologies and what was out in the field? And then under generally best practices, did you draw on the very best tools to ensure that you were actually rendering it unre-identifiable? And I think both of those elements do raise the bar, because it actually suggests yet again that someone can't just kind of throw up their hands and indicate that to their mind it was anonymized.
So what's the argument for building in generally accepted best practices and reasonably foreseeable? I understand that both may align with Quebec's law, notwithstanding Mr. Garon's point, which I think is a very good one, that perhaps embedding requirement for things to be specified in regulation may actually strengthen it further and address some of the concerns from my colleagues across the way here that I think all have expressed the same concern that industry shouldn't be setting the standards themselves, but in fact, it should be a regulation, perhaps. Can you?
I think there's...
Sorry, I kind of went on and on. My apologies. I have a tendency to do that sometimes. Just to be clear, the question I was asking, what's the argument between best practice, having generally accepted best practices, and reasonably foreseeable?
Reasonably foreseeable aligns with the generally best practices in the sense that if it was reasonably foreseeable, one has to draw on those generally acceptable best practices on the anonymization front. In that, if you're not, if you're holding both ends, essentially reasonably foreseeable, but then you're also mandating that people are really up to date on the best practices for anonymization, you're essentially linking those two to say, if it was reasonably foreseeable, in part because you're actually using the generally acceptable best practices.
So they sort of, they mutually support one another. They're kind of complementary concepts, and they both align with Quebec's law, although there's one key difference that in terms of the way that if we voted down NDP2 and kept generally accepted best practices, and we support G2, which is reasonably foreseeable, it aligns with Quebec's law, but the only element that doesn't completely align is having the regulation, the one that specifies both.
That's correct.
And so I think, what I'd like to propose to my colleagues is that we vote down NDP2 and that we embed a wording that includes best practices to be defined in regulation. And I have suggested wording for that. If we get to G2, I'd be happy. But I do think that we need generally accepted best practices in there in order for those to be defined by regulation. So, and I think that addresses some of the concerns that have been expressed, which I think are valid concerns to have. If the concern is that industry groups can essentially define best practices however they want, this would account for that and say would essentially make it dependent upon regulation, which I think would strengthen it and would allow for certainly consultation to be done, because I think that would be very important, but that the regulations would be set or those best practices would be defined essentially by the government and the OPC. So, and this would align, I believe, with Quebec's law. So it's what I would propose as a compromise here, given the debate that we've had. And I hope that maybe we can vote down NDP2 together and then move in good faith on a sub-amendment to G2, which would strengthen it in the way that I've suggested here. Thanks.
Merci beaucoup. J'ai Monsieur Viss.
Thank you. Mr. Biss.
Two questions for clarification. Per my last question, I might have missed it. Did you say in Quebec's law has a similar clause to Clause 5 for greater certainty like we have on page 8 of the law? Or was that solely in regulation that Quebec deems anonymized data as not subject to its act.
It's not the same clause. I'll turn to Ms. Angus. Potentially to clarify, but it is the same. It is the same outcome, which is that anonymized information is not subject to the act.
Okay, but that is through, that's through regulation, or that's embedded in the statute?
So the statute says information anonymized under this act must be anonymized according to generally accepted best practices and according to the criteria and terms determined by regulation. It is Article 23, and the name of the article is destruction or anonymized. So when you get rid of personal information, you're either destroying it or turning it into anonymous information, so you can't re-identify.
Okay, and once it's anonymized to a standard acceptable by the government of Quebec, then it is no longer subject to the statute.
Which is why it's in the same category as
As
destructed information.
Thank you. Okay. My second question relates to the broad discussion we've had, but it's a question that hasn't been asked yet. Does C-27 provide for the scenario whereby data once deemed anonymized under the possibility of new technology is deemed to be re-identified? Would it be therefore subject to the act again if that data was re-identified? Is there a clause you can specify in the bill that addresses that scenario?
So that's one of the things that generally accepted best practices does. It requires organizations to ensure that their information is anonymized in accordance with generally accepted best practices. Those practices evolve. For example, ISO has a standard on anonymization. That standard may evolve. If you're no longer compliant with that, with those generally accepted standards, then your information is no longer anonymized pursuant to the Act, and then it becomes identifiable and therefore becomes personal information.
Okay, my concern would be that I just, based on what the Privacy Commissioner said, I don't see why just the term anonymize would preclude the use of best practices in regulation. And from what we heard, I'll stop right there. I think, yes, I'm
Merci,
good.
Monsieur Vice. J'ai Jean-Denis Garon.
Mr. Viss and then Mr. Garon, and we'll carry on. Well, I'm addressing myself to you, and I feel a little bit ill at ease because the process as it led us to the clause by clause is not evident. The department has consulted privately. They met with individuals or organizations. We don't have any documentary result from that. As a parliamentarian, it's quite difficult for me. I'm sure it's not a choice made by the officials themselves. But they're trying to sell us this bill a lot more than answering our questions. And I don't know where the information comes from. So I find that very difficult vis-a-vis the trust that we have in that. We're looking to align it with the Quebec bill. And in Quebec, they say we can regulate, and we should. So maybe they're pitching us something here. They're trying to sell us this. We're working in good faith. I'm not trying to do a filibuster here, but parliamentary work is quite difficult. I know it wasn't your choice, but you're trying to pitch us something here. We want answers. We don't know all that went on. We don't know exactly what the corresponding regulations and laws are in each province, for example. But I don't see why you couldn't just simply accept that and make sure that it is aligned with the Quebec process. It's quite problematic for us as parliamentarians, and we have to be very rigorous. So I have a question. Is it up to the industry to determine what are best practices? And how can we arrive at some compromise on that? I saw the other amendment from my colleagues suggesting that enterprises should conform to best practices as outlined in regulation. Would that leave the government the opportunity to not regulate and not adopt any regulations and leave it up to industry to decide what are best practices? The law is already drafted that way. It seems to be the preference for the government. Can the government take the decision to not regulate? Well, thank you for the question. It really depends on the specific wording in there. If it's a prescribed, as prescribed in regulations, well, then the government has to provide regulations. Anonymize means to modify in a permanent way personal information in keeping with best practices in order to assure that there is no reasonably foreseeable risk in the circumstances that an individual can be identified directly in any way whatsoever other than in methods prescribed by regulation. So concretely, where does that leave us?
Comme dit comme ça, ça indique que le règlement.
Well, I would indicate that regulations, well,
It's required to be able to fully live out the clause, and so the government would be under obligation to have the regulations in place to be able to further the effort.
Parce que, à ma compréhension,
well, in my comprehension, it's not the commissioner or federal or provincial that would be doing that. You know, it would be an empty regulation. No, what? I'm trying to understand, really. We're trying to do the right thing here. Mr. Moss has indicated that in case, you know, if there's any doubt, the standard has to be very, very high. What the government was saying in its original proposals was to let business take care of it. Well, we're trying to find a compromise here to understand which compromise is being effected here by way of regulation. Well, suppose we remove best practices. There's a very, very important role. Gives business a lot of authority and power here, encroaching on that of the OPC rather. Very important protections are going to be in the hands of business. Now, generally respected best practices, usually that's set by the industry. Mr. Turnbull is looking for a compromise here. So, if government, with the sub-amendment as proposed by Mr. Turnbull, would allow the government to remove itself from its responsibilities. Do you understand? Well, there are three aspects to this. The introduction of a concept of best practice gives us an interim standard that can be used to use a proper methodology to anonymize. That's what the regulations would call for. We need standards that are clear, unambiguous, for the management of the data. Second aspect, with enforcement measures taken by the authorities, we can continue to promote or accept the continuous ongoing evolution of technique. by enforcement standards.
It's come even further precision about how this will be understood, and so in the absence at outset there'll be a commitment that you have to use the best technology available. That will then get laid out in the regulation making process, which is consultative by nature, and then further established in enforcement.
Okay.
Merci beaucoup, Monsieur Garon.
Thank you, Mr. Garon. Mr. Massé.
Reinforce that I think are very important. I know that we're talking a little bit about G2 as well, which got introduced later on and apparently needs some fixing. But the first argument the government had against this, you actually try to use the Privacy Commissioner against the Privacy Commissioner, who the Privacy Commissioner still stands by the suggested change for a lot of different reasons, and that hasn't altered. The second part was to use the fear factor with Quebec, which has been diminished in all important aspects because the reality is that the former Commissioner of Quebec's Information noted that there's important distinction in the regimes, and actually what this could do is actually provide more protection for Quebec through the Privacy Commissioner. So that's an important distinction to make. If we are going to move to some type of regulation, that also means taking away from Parliament and putting that in the hands of others, more importantly, that are less independent. And I cannot see for the life of me, when we look at best practices, how it's then assumed that the Privacy Commissioner that would have the worst practices. In fact, the Privacy Commissioner could actually have awesome practices. It could be quite different than that of the best practice argument. And I can tell you some industries at many times, best practices included things like, I don't know, like not having seatbelts in cars or to be optional in cars. Those are different times and point where we've had to change and alter. And we have an industry here that's emerging that's very important. And I, again, think it's a philosophical thing. I do not want to lend this go back to the government. And it was interesting to hear the arguments about this, to keep this in here from organizations that have on their board of directors Loblaws, Sun Life, Private AI, TELUS, Microsoft, TD Bank, BMO, CIBC, RBC, Rogers, Magna, two of them, Metrolinx, a whole bunch of other lawyers and so forth. And that was the primary discussion used to actually support this. So with that, I hope that we can move on to a vote. I think it's important that we have this philosophical point kind of finished in the sense that I'm siding with the Privacy Commissioner, I'm siding with the public interest, I'm siding with that versus taking it out of our hands and, more importantly, giving influence to the backrooms, lobbying, and other nefarious organizations that may not have the public interest at heart, but they have your information interest at heart.
Merci, Monsieur Massé. J'ai Monsieur Williams suivi de
Mr. Williams, followed by Mr. Turnbull.
And I do agree we need to get this to a vote. Look, I think this is a long, good debate. This is a really good debate because I think it looks at the core of what we're trying to protect here. I believe that when we introduce language other than the simplest language, especially for anonymized, we are actually introducing ambiguity in the fact that it is going to be the Privacy Commissioner and the courts that set precedents. As my colleague, Mr. Massey, just mentioned, it's going to the Privacy Commissioner who's going to give best practices, and the courts through precedents who will look at cases and then set those best practices for business. It's not up to the government to have an evolving list, because when it was mentioned from the GDPR, and why does the GDPR, which we consider the gold standard for privacy, not explicitly define generally accepted best practices? Because they say it aims to provide a broad framework that can adapt to evolving technologies and societal norms. And that's because they've removed it, not because they're adding it in. And the reason for that is Parliament can in no ways be as quick as business can be to protect it, but also can in no way be as quick as can be to ensure that it gets out of the way. And if we want businesses to protect privacy, it's going to the Privacy Commissioner, who has to be the end-all to what privacy is and how it's debated and how it's adhered to. And again, the courts would be the final say. But adding language in, including there is no reasonable foreseeability, because again, we're not adding context to that, adding accepted best practices without concrete context to that is adding ambiguity to anonymization, which we don't want in a bill that is supposed to protect privacy for Canadians. So for both of those amendments, we'll be voting no, and hopefully to move on to the important parts of this bill. Thank you.
Merci, Monsieur Turnbull.
Well, not surprising. We've already had the debate, but Mr. Williams, I respectfully disagree with the fact that you referenced something about keeping up to date and evolving, which is exactly what the best practices, generally accepted best practices, is designed to do. I've sent around a sub-amendment for G2 just because Mr. Garon and I discussed it and he was referencing it, and I wanted to make sure that every
Mr.
member
Turnbull,
had
just
the wording.
1 second, Mr. Turnbull, Mr. Massey, on a point of order.
I understand that you have some latitude that's necessary for this, but now we're trading notes on a future amendment without dealing with the current amendment in front of us. So there's, I think, at a certain point in time, we have to deal with the amendment in front of ourselves.
Correct, yeah.
We do,
Can I
of
speak
course.
to that? Point of order?
I'll respond to that. We do, of course, Mr. Massey, you're correct, and we will, in any event, deal with NDP2 before we go any further. However, given that G2 is rendered moot, if NDP2 is adopted, I think it's fair to allow for a discussion of the amendments going forward as well, because they're impacted by the two.
I guess that's
But
fine.
we're not
it's
going to
just that-
vote. We're not going to vote on anything else before NDP2, of course.
Okay, yeah, but I guess the only point I would make to that, and I appreciate your ruling, Mr. Chair, but none of that was ever introduced by the government until basically a few minutes ago. So we've been dealing with this amendment for hours and hours, and even in the original intervention by the government, they really didn't deal with this issue, and all of a sudden it's coming up now. So perhaps in the future we could have some more courtesy with regards to why we spend so much time on something and then see another thing come to fruition.
Duly noted, Mr. Massey. Appreciate your comment. I'll yield the floor back to Mr. Turnbull.
Yeah, I mean, in this committee, there's lots of things that are worked on the fly, and in this particular case, we're trying to create a sub-amendment that both aligns with Quebec and deals with some of the concerns that committee members have raised. I call that compromise, call that collegiality, a constructive process. Those are the intentions behind circulating that. So I sort of take issue with the sentiments from Mr. Massey on that. It's actually a constructive way to move forward. And we think that I think it actually deals with a lot of the concerns that committee members have brought up. Obviously, we can debate that. And I do think that, because G2 hinges on the vote on NDP2, that it's perfectly legitimate to bring that up and have the conversations about how these concepts work together, all on the same definition of anonymize, and I think that's important. So I wonder, I don't know if there's a path forward here, but I wondered if we had a moment to suspend and consider the wording, whether we could find a path forward on what I've circulated and then come back and vote on NDP2. So, Chair, respectfully, I would ask if committee members would be willing to suspend for just 5 minutes and consider and see if we can find a path forward on both NDP2 and G2, and when we come back, perhaps we can vote.
I'm inclined to allow to suspend for 5 minutes, and then when we come back, we vote on NDP2. So is that fair with everyone?
Well, just let's make it clear. Is what we do is we go in camera virtually, so the public doesn't see what happens. Is we negotiate something with closed cameras and closed doors, and then we reemerge with a decision after we've been in public all this time. So I just want to be clear on that.
I understand, Mr. Massey, that Mr. Garon has read the text of the sub-amendment that was sent to committee members on the record, so that's essentially what will be discussed by members. But the only reason I see is that for some time members can really read the text, take some time to read it, and then if we want to debate some more, we can always debate some more, but NDP2 will still be, of course, on the agenda and ready to be voted on when we come back in, I'd say 5 minutes, because we're already almost done with this meeting. So 5 minutes for members to read the sub-amendment, and we'll be back. believe the white smoke has emerged. So, Mr. Turnbull.
Yeah, if I may. So we had a good discussion among all of the different parties represented and their vice chairs, and just discussed how we could work on a sub-amendment to NDP 2. And essentially what we would do is take out generally accepted best practices, but still include language on reasonably foreseeable risk. And so to add that back in, that we would work on wording to return to the committee at our next meeting so that we could move past this fairly quickly. That would obviously mean G2 would not be moved or would not be admissible, I guess. So we'll do that work in the interim between now and the next meeting so we can get past NDP 2 and move on. That's what we agreed to. And then the only other thing is I know Mr. Perkins has a motion that he wanted to deal with, and we thought perhaps we could deal with that for the last 10 minutes, Chair, if you're okay with that.
You're making my life and my job very easy, Mr. Turnbull. Thank you very much. So we'll get back at the next meeting with the NDP2 as amended. So, Mr. Perkins, the floor is yours for your motion.
Thank you, Mr. Chair, and thank you, MP Turnbull. And I think there was a caveat there, which is that MP Massey wants to make sure and be comfortable with the wording, since it's his original amendment to the bill. But thanks for doing that. We put on notice last week a motion, and we've had. Won't go over Schedule versus Schedule 1 again, but in that discussion, we're talking about Schedule 1 and Schedule 2. And one of the concerns we have is that around Schedule 2, I talked about, but that the Deputy Minister spoke to a group of lawyers at the TD Bank Tower and basically said that the content management definition of high-impact systems would allow them basically to ask for and access AI algorithms basically in any content moderation that I believe he termed as bias. So with that, I'd like to move the following motion that in relation to Bill C-27, an act to amend the Consumer Privacy and Protection Act, the Personal Information and Data Protection Tribunal Act, and the Artificial Intelligence and Data Act, and to make consequential and related amendments to other acts. And given that A, Simon Kennedy, the Deputy Minister of Innovation, Science, and it says economic development here, but I think it meant industry, was the keynote speaker at the, quote, Business Leaders Breakfast at McCarthy Tétrault Strategic Advisors at the TD Bank Tower on November 7th, 2023, and B, given that the Deputy Minister read from a pre-approved 20-minute speech discussing the department's most recent developments on the use of AI, which included discussions of moderating and prioritizing the social media content Canadians see for the purposes of combating online misinformation through Bill C-27, the committee therefore orders the production of, 1, the draft speaking notes recommended to the Deputy Minister's use for the department in relation to the breakfast speech, and 2, the final version of the speaking notes which the Deputy Minister relied upon during his appearance at the breakfast, provided that those documents shall be deposited with the clerk of the committee in both official languages no later than, it said today, I'm going to suggest April 22nd, that's a week from now, 2024, but perhaps somebody could give us an indication if that's enough time to get it in both official languages, since I'm not aware whether it was produced in such a language. So we could obviously be flexible by another week, perhaps in that date, but surely with the translation resources available to the Government of Canada, that the Deputy Minister's speech could be translated within 2 weeks.
Thank you, Mr. Perkins. I have Mr. Turnbull on the motion.
Yeah, so we don't have a problem with this. I think the only thing was the date. Could we amend to say as soon as possible? Would that be sufficient for the Conservatives? And that way, you're sure to get it as soon as we can make it available.
Mr. Perkins.
I understand understand the amendment. Well, and Pedro, and that's why I suggested the 22nd or perhaps a week later. But I think nothing focuses the mind like a hanging in the morning. So if we could set a date, that would be perhaps more appropriate to make sure that the government works towards a specific date. So I would suggest, say, 2 weeks from now, and if that's a problem, obviously, that could be conveyed to the clerk, and we can seek another more reasonable time.
So let's say May 1st, would that work?
Sure.
Yeah, okay. So is there a consensus to have the date at the end of the motion be May 1st? Merci. And is there a consensus on the motion, or is there any more debate on this? Do I need a vote? No. Okay, so the motion is adopted. Thank you, Mr. Perkins. And thanks to the officials for joining us yet again today, and see you Wednesday. Meeting adjourned. I'll go check with them.